Slip and fall cases and depositions. If you have been injured in a slip and fall and you decide to take your case to court, you might be summoned to make a deposition. A deposition involves the plaintiff, the injured party, answering questions under oath. While many people think depositions take place in a court, many depositions actually take place in a lawyer's office. The plaintiff, defendant, and any witnesses may be summoned for a deposition. However, if a witness to your slip and fall refuses to be involved in a deposition, they may be compelled, forced by law, to do so. Many depositions take place under agreement by both parties and their lawyers. During the deposition, the lawyers will try to get the exact story as to what happened before, during, and after the slip and fall that resulted in the plaintiff's injury. When a deposition takes place, there are usually few or no surprises once the trial goes to court. The plaintiff's deposition. In a slip and fall case, the deposition can be crucial to the defense. An attorney working for the defense will try to work out how good the plaintiff is in answering their questions. The deposition also lets the attorney find out more about the plaintiff's background and how their accident occurred. The deposition is usually the plaintiff's first chance to explain how the accident occurred. If the plaintiff answers the questions well and is seen to be truthful during their deposition, they may get a reasonably good settlement. However, if they don't do a good job, the settlement might not be that good, and in some cases, they may not get a settlement at all. The background questions. The first questions that a defense attorney may ask the plaintiff are likely to be about their educational, medical, family, and military background. They are also likely to ask about their work history and even where they have been living for 20 years. The defense attorney may seem to be asking a lot of questions about the plaintiff's history, and it can seem as if they have nothing to do with the case. Most attorneys can ask as many questions as they wish, but this can depend upon the state they're living in. However, if the plaintiff's lawyer thinks the questions have nothing to do with the case, it's likely that they will object. Unfortunately, many questions can be asked, even if they seem completely unconnected to the slip and fall claim. Your medical history. The defense attorney will ask about the plaintiff's medical history to determine whether they have a condition that makes them more susceptible to slips and falls. The plaintiff's lawyer is likely to prepare the plaintiff for such questioning, but it can still raise some unexpected questions. The defense attorney may ask questions such as: when were you last hospitalized? Why were you in hospital? Explain to me why you visited hospital in the past. Can you tell me the name of all the doctors you saw over the last 20 years? As probing as these questions may seem, the defense attorney can legally ask them. However, if the plaintiff is uncomfortable answering these questions, their lawyer should have already come up with a strategy to counteract or help with answering these questions. How the slip and fall occurred. At this stage, the defense attorney will want to know exactly what happened. They may ask the injured party to explain what happened, before following up with a set of questions that is likely to cover every single part of the accident. For example, the defense attorney may ask: what shoes were you wearing at the time of the accident? What else were you wearing? Do you know how you slipped? Did you see what you slipped on? Which foot did you slip on? How wide was the step that you slipped on? How deep was the step that you slipped on? Were you paying attention to where you were walking? What did you do immediately after you fell? The defense attorney will ask the plaintiff so many questions that after a while it may seem like there is nothing more to ask. The good news is the plaintiff's lawyer is likely to prepare the plaintiff for such questioning, but it can still raise some unexpected questions. The injuries the plaintiff sustained. The defense attorney is likely to focus on the injuries last, and they are likely to ask about the diagnosis, medical treatment, prognosis, health insurance, medical bills, loss of earnings, time off work, etc. It's likely that the attorney will inquire about how the injuries impacted on their relationships, their home life, and how they feel about the world. This may seem somewhat bizarre, but the attorney will try to determine if the plaintiff's attitude has been affected by the slip and fall. Please read What is Pain and Suffering, For more information. The defendant's deposition. When it comes to the defendant's deposition, it is likely to focus on the upkeep and maintenance of the property where the accident took place. The plaintiff's lawyer may also ask the defendant a range of background questions, and if they knew about an unsafe condition, if they had attempted to fix the issue, what they did to fix the issue, who they hired, if applicable, to fix the issue, whether the issue had occurred before, if another person was injured in the same area, if another person had made a complaint about the area. The witness's deposition. The witness's deposition is likely to focus on whether they are biased towards the plaintiff, and what they saw. The defendant's attorney may be very interested in how biased the witness is towards the plaintiff or defendant, as this can make a big difference to the case. If it turns out that the witness favors the plaintiff a lot more than the defendant's attorney is likely to highlight this. While a deposition may not be easy to attend, and some of the questions may be uncomfortable and seem irrelevant, it is an integral part of a slip and fall case. If you do not wish to attend a deposition, you may wish to change your mind about filing a slip and fall claim. If you have already filed a slip and fall claim, you and your lawyer should start to prepare for your deposition, as you may be compelled by law to give one.